Good afternoon, everyone. Welcome to the Malcolm Renfrew Interdisciplinary Colloquium. It is Tuesday, March 29th, 2022. My name is Kenton Bird, and I'm the co-coordinator of this series, along with my colleague, Dan Buckovich, who is in the same room with me for the first time all semester. This is only the second time this semester where we are meeting both face-to-face and on Zoom. Before introducing today's speaker, let me tell you about next week. We are returning to our roots in some ways in getting out to see different parts of the campus. And on Tuesday, April 5th, we will be at the Bar Entomological Museum, the Insect Museum over across the street in the Agricultural and Life Sciences building for a tour with Luc LeBlanc, who is the curator of that museum. And I don't know yet whether he wants us to come up to the second floor where the museum is or meet in the lobby for an overview. So next week's program will not be available on Zoom, only in person. And then 2 weeks from today, we'll hear from Jeffrey Kyung McLean, who is a professor in the history department and director of the Idaho Asia Institute. And that program will be both in person and a Zoom live stream as well. So we're breaking out a little bit of from our COVID bubble and exploring parts of the campus. More field trips and tours to come later in April and in May. Over the 20-year history of the colloquium, we have had speakers from faculty, we've had visiting scholars, we've had graduate students and postdocs, but to my knowledge, we have never had a visiting jurist. And we are grateful to the College of Law for sharing their Judge Alfred Budge visiting jurist with us today. And that is a program to strengthen the connections between the Idaho judiciary and the College of Law. Our speaker today is on somewhat familiar territory. Molly Huskey is a graduate of Moscow High School. She earned an undergraduate degree in public relations from what was then the School of Communication, now the School of Journalism and Mass Media, and then her JD from the College of Law. She has worked as a district court judge, as a public defender, and since 2015, a judge on the Idaho Court of Appeals. And she is going to tell us about Idaho's court system, what it does and how it does it. So please welcome Judge Molly Huskey.
Thank you very much. It is an honor to be back. I love Moscow. I love this School of Law. And so it is really a pleasure to be back with you all today, whether you are here on Zoom or whether you are here in person. I really thought the best way to describe sort of the appellate courts is to sort of do a soup to nuts. How do we get a judge? How does a judge get an appellate court case? And how do they decide that case? So we have a unified court system in the state of Idaho. The administrative procedures are all governed by the Idaho Supreme Court. And our Idaho Supreme Court and our trial court district courts, which are felonies and civil cases over $10,000, are creatures of our state constitution. They were created when we became a state by virtue of our constitution. The Court of Appeals and magistrate courts were created later, subsequently by statute. The magistrates in 1975 and the Court of Appeals by legislation that was passed in 1980. There were 3 initial members on the Idaho Court of Appeals, one of whom is with us today, Don Burnett. When he retired, he was replaced by Judge Karen Lansing. When she retired, I replaced Judge Lansing. So technically I have the same seat that Dean Burnett had when he was on the Court of Appeals. So there are 2 ways really that one can become an Idaho District Court judge, a judge on the Court of Appeals, or a Supreme Court judge. The qualifications are set forth by statute, and they are the same for all of those positions. You have to be at least 30 years old. be a citizen of the United States, and an elector, a voter in the state of Idaho. You have to have been a legal resident in Idaho for at least 2 years prior to the election or appointment, and be a member in good standing in the state bar. And then you have to have been admitted to practice law for at least 10 years. So if you think about the timing, we do not, I don't know if ever, have seen a judge who is 30 years old be appointed to the bench, because it is extraordinarily difficult to graduate from law school by age 20 and then have that 10 years of experience. So typically, judges are not quite that young. Magistrates are appointed by a commission. They are appointed initially for 4-year terms, but their first 18 months is probationary, and then magistrates stand for retention elections thereafter. So once one is appointed a judge or runs for a judicial position, there really are 2 ways. So we'll use my court, the Court of Appeals, as an example. Our terms are 6 years, just like at the Supreme Court. Trial court, district court judges have 4-year terms. And if there is a vacancy within that 6-year period, then there is a process by which the judge is appointed. There is an application, it is 11 pages long. That application is then forwarded to the Judicial Council. The Judicial Council is made up, as we speak, of 6 members with an adjunct. There are 6 members appointed, one of whom is a district court judge by members that are approved by the State Bar Commission. 6 members are appointed, or 3 members are appointed by the governor with confirmation by the Senate. There is an adjunct member, which is generally the Chief Justice of the Supreme Court. By statute, the Judicial Council must forward no less than 2 and no more than 4 names to the governor, who then selects somebody off that list. And that person then fills the remainder of the term. At the end of that term, all judges, district court, court of appeals, and Supreme Court judges sit for a contested election, which means if an individual has $300 and can fill out a form or gather the statutory number of names, they go down to the Secretary of State's office, and you have then a contested election. There has not yet been a contested election on the Court of Appeals. There have been contested elections at the district court level and at the Supreme Court level. There are a couple, do we have questions in the chat, Ben? Okay, just a couple of comments. So there are lots of different ways that judges can be appointed. Some states have partisan elections. Some states have nonpartisan elections. Some states do legislative appointment. There are 2 states, and some states do gubernatorial appointments, but we do the hybrid system, which is the merit selection process of the Judicial Council, and then the subsequent contested election through the electorate. So once we have a judge, now we have a case. There is a case in the district or magistrate court, but because at the time the Idaho Supreme Court was created by statute, there were only district courts. All appeals are filed in the Supreme Court. They do not come up through my court. So we have all appeals going to the Supreme Court, and then the Supreme Court will assign cases to the Court of Appeals. So the Supreme Court has certain cases that it must, by virtue of the constitutional mandate and statutory mandate here. It has original jurisdiction for issues, writs of mandamus, cert, prohibition, habeas corpus, and any writ necessary to the exercise of their appellate court jurisdiction. So the Supreme Court has a plenary power of appellate court jurisdiction. They also hear appeals from the Public Utility Commission and the Industrial Commission, and they hear capital cases, cases in which there is a first-degree murder and a death sentence has been imposed. All other cases they can assign to us. So 100 years ago, there is a little brown box. It is in the lobby of the Supreme Court building. And the Idaho Supreme Court law clerks would go down to the clerk's office, and the names of cases would be written on strips of paper, and they would be put in this box, and they would take out a slip of paper, and that's how that justice was assigned that case. Fast forward 100 years, we have new technology. Justice Larry Boyle built a new box. So we have a new wooden box that we now use. And now the law clerks are given a list of case names, and there are numbered tiles inside the box. The Supreme Court law clerk will draw out a numbered tile. That tile number will correspond to the name of a case, and that is how Supreme Court cases are assigned in the state of Idaho. Everything that is not retained by the Supreme Court, they then will assign to the Court of Appeals. The way in which we hear cases is there is a random wheel assignment. So we hear cases, there are 4 judges on the Idaho Court of Appeals, and we hear cases in panels of 3. So there is a wheel that has a panel, let's say I am authoring an opinion with 2 of the other judges, I'm authoring opinion, the other 2 judges, there are configurations. There are 12 permutations total. And those are then randomized, and as the cases come in, they are assigned on that random wheel. And so that is how we hear cases. So by statute, the statute mandates that the Supreme Court assign cases to the Court of Appeals with due regard to the workload of each court, to the error review and correction function of the Court of Appeals. So by statute, we are an error correcting court. The Supreme Court deals with cases by statute of substantial public interest or in which there are significant issues involving clarification or development of the law. So we sometimes say that we are the error correcting court and the Supreme Court is the precedent making court. That I think is a good general description. So we look at a case with an eye towards correcting the error in that case only. That is the case in front of us. We typically do not think about policy making or broader interpretations. We look at the narrow issue in that case. But because so many fewer cases reach the Idaho Supreme Court than reach the Idaho Court of Appeals, there are times when we are creating precedent on the Idaho Court of Appeals, and that is binding precedent for inferior courts in the state of Idaho. So we are typically an error correcting court, but there are some instances when we do have to create, interpret a statute, address an issue in the common law. And then of course, the Supreme Court on discretionary review can review our decisions if they feel like that is appropriate. So if you think about the differences in what we do, and you think about we just correct error, but the Supreme Court really resolves doctrinal disparities or issues that have far-reaching public implications, then it helps us think about the way in which each court will look at a case. Although the Court of Appeals opinions are binding precedent on, by statute it says, or by case law, it says inferior court, but really they aren't, they're just trial courts. The Supreme Court will sometimes look at cases a little bit differently. And the Supreme Court does not review when a case is to the Supreme Court on discretionary review. They do not review the decision of the Court of Appeals. They go back and review the trial court decision. And the caseload is very clear that although we have an opinion and they give due regard to that opinion, they review the work of the trial court. So once a case, and if anyone has questions, please do not feel compelled to hold questions until the end. Feel free to jump in at any time. So when we think about error, there are a lot of things that we balance. We need to balance the finality of the decision, which is really important to have respect for the rule of law and respect for the court system. The courts don't have the power of the purse or the power of the sword. And so our power depends on the public perception of the legitimacy of our opinions. And one of the ways that the legitimacy of court opinions is affected is the length of time it takes a case to be resolved, and whether the parties, when a case is resolved at the trial court level, can predict the way in which that decision will be viewed by the appellate courts. And so the lens by which we view trial court opinions is the standard of review. And standards of review are ways to facilitate both respect for the system, but also to create judicial economy. We don't want to relitigate trials on appeal. That's not what appellate courts do. They are not a relitigation of the issue. What we do in our court at the Court of Appeals is we review the decision of the trial court and we decide, based on the kind of decision that it is, what level of deference we are going to give to that trial court. And there is a spectrum of deference that is given to the trial court, because it is important that there be finality in the court system. So standards of review really are a way in which we balance the power between the different courts. They enhance judicial economy. They standardize the appellate process so that from judge to judge, you get the same modality of review. And they give the parties in a lawsuit some predictability. If it is this issue, it will be this standard of review. And here's how the court has used that standard of review in other cases, so they can predict, to the extent they can predict, the likelihood of the outcome on appeal, because they may or may not want to pursue the appeal, depending on how they think the issue may be viewed and resolved. So there are really two kinds of error that all appellate courts, but primarily my court, will look at. There are factual errors and there are legal errors. And factual determinations get the most deference for a trial court, because the trial court is in the best position to see the witnesses, to assess their credibility, to determine what that fact will be. And so we often will say in our court, if the trial court did not make a factual finding, unless there is a circumstance in which we can infer a factual finding from the judge's legal reasoning, the fact does not exist for purposes of appellate review. So in a trial court, you have witnesses. There often are conflicting sides to a story. There are always different perspectives. You have experts. All of that is determined in the trial court. And the trial court will assess all of that credibility. He or she will apply the relevant law and reach a conclusion. And it is that conclusion that we look at on appeal. So if the trial court's factual findings are supported by what we call substantial and competent evidence, it's evidence that a reasonable mind would view and find to be believable, then we do not reassess that factual finding. That is the fact of the case for purposes of our legal review. There are legal errors, and there is a spectrum of deference that is given to a district court's legal determination. So, for example, the most deference is given to discretionary calls by the trial court. And that is a fairly broad standard. The standard is, did the court correctly perceive the issue as one of discretion, i.e., do I have the authority to make this decision? Did the court act within that discretion? Did the court apply and act within the relevant legal principles? And did the trial court reach that decision by an exercise of reason? And I think the easiest or most simple example is a sentencing decision. Sentencing in a criminal defendant is a discretionary decision with the trial court. Now, the legislature has set what those penalties are, but often there is a range of penalties that by law can be imposed. So if the court understands that it has the discretion to impose within that range and has looked at the statutory factors that govern how it makes its decision, and it articulates that for the record, then we would defer to that trial court finding and say the trial court did not abuse his or her discretion in reaching that decision. It is a very difficult burden to prevail on appeal in an abuse of discretion standard of review, because there is so much deference. And if we think about that and we think about the importance of finality, the appellate court, the Court of Appeals, we are not in a position to assess the credibility and take all of that trial testimony. We want that decision to be final. Then you have sort of next on the spectrum are mixed questions of law and fact. So a legal question, a purely legal question, is reviewed de novo, which means it is a free review. What that means is that we will look at the facts as found by the trial court, but we will review the legal issue. Typically, you see that in Fourth Amendment cases, search and seizure. It is a mixed question of law and fact. So the trial court makes the factual findings, and we say, Well, if those are the facts, was there reasonable suspicion? Free review or a de novo review does not mean a free review of the case. It does not mean we can go back and look at any issue that we think is interesting or fascinating. It has to be an issue that was addressed or presented to the trial court. So another limit on the ability of a Court of Appeals judge to make a decision is whether the issue was preserved. Was it raised? Did the trial court get and have an opportunity to make a decision about this issue? And if the trial court didn't have an opportunity to make a decision about that issue, there are some instances where we certainly can look at that issue. But if you have been the trial court judge and that case goes to the intermediate court and you say to yourself as a trial court judge, well, they're deciding an issue I never even got to hear. I never even got an opportunity to make a decision about that. You might perhaps be a little frustrated as the trial court judge in that context, right? Because you didn't have an opportunity to weigh in. So a free review is a review of preserved issues. Now, there are arguments that a free review really should be a free review of the law. Because if the trial court made a mistake applying the law, should that error be perpetuated in the appellate courts simply because one of the parties didn't say particular words or a particular phrase? And so it is a really interesting question on the scope or the limit of the court's authority to hear an issue. There is a lot of scholarly work on restraints on judicial authority and a preservation requirement that this issue be preserved in the trial court can be a restraint on an intermediate court of appeals ability to hear the issue. So we have those mixed questions. We have the free review. Those are all sort of how we will review it in the first instance. Now, what if down in the trial court, somebody didn't preserve the issue? They didn't make an objection. They didn't say, Judge, can you fix this? This is a problem. Can we still review that? And the answer is yes, if it is a constitutional issue. It is called a fundamental error review. And in that particular instance, there has to be no objection on an unwaived constitutional right. And if there is an unwaived constitutional right, then the error has to be clear from the record, meaning can we look at the record without any additional facts or information and identify that there was that error? And if there was, then the defendant has to demonstrate that that error actually affected the outcome of the trial. It is a very high standard. So I should take a step back, and in the appellate court, we get what we call the record. And the record is a compilation. We used to get it in a red binder with two prongs, and it was every document that was filed in the trial court. And we would get a transcript of the proceedings. And that is what our decision is based off of. So when something has to be clear in the record, we have to be able to look at one of those two documents and determine if the error is there. Now, some states will call it fundamental error. Some states call it clear error. There are lots of different names. And in 2010, our Idaho Supreme Court tried to get its arms around, is it clear error? Is it structural error? Is it fundamental error? This was one of those areas where there was lots of cases and maybe both the Court of Appeals and the Supreme Court had not been as careful about word choice as they maybe should have been. And so there was a lot of different standards. So fundamental error has to be an unobjected to constitutional error. It cannot be a statutory right, or a court rule. It can't be based on a statutory right or a court rule. So rules of evidence are not reviewed under a fundamental error standard generally, unless you raise them as an independent constitutional violation. There's a recent case that says they can come up there. Court processes generally are not viewed as constitutional errors. If it was an objected to error, then we go back and use either the abuse of discretion or the legal review. But even if we find an error under any of those standards, under any of the deference anywhere on the scope, there is still the question is, even if there was error, did it affect the outcome? Did it affect a substantial right of one of the parties? And so even if we find there was error, if that error was harmless, i.e. it did not affect the substantial right of the party, then we would not reverse the trial court. We would say there is error, but it is insufficient to reverse or vacate whatever the issue is that is in front of us. Yes.
We have a question from a member of our Zoom audience. What would be an example of a waived constitutional right?
So, for example, a party could, they have a constitutional right to have a speedy and public trial. And under circumstances, they may decide that they would waive that constitutional right. Maybe their attorney needs more time to gather evidence to file a motion. Maybe they want to let some time go by so things can cool off, and they can waive that right to that speedy and public trial. When an individual pleads guilty, they waive their constitutional right to have a trial by a jury of their peers and have every element of the crime established beyond a reasonable doubt. They could waive that constitutional right and yet still have issues that they would like resolved on appeal. So in those contexts, there would not be a fundamental error analysis. There would be a different kind of analysis that we would apply. So I think there is some real, perhaps, misunderstanding of how an appellate court would decide a case. So we have our judges. You go through the Judicial Council, you get your appointment. You've now been assigned your case. The case now comes to you, and I think, practically speaking, what happens next? So what happens next is that, first, I think it's really important to say that in my experience, the judges of Idaho, both trial court and appellate courts, really, really ascribe to preserving and protecting and promoting the rule of law. And the rule of law is a principle by which all people and institutions and entities are accountable to the law when the law is publicly promulgated or made, is equally enforced, is independently adjudicated by the judges, and is consistent with certain fundamental human values. I truly, in all of my years as a practicing attorney and as a judge, my experience has just been that all judges take very seriously their obligation to that established rule of law. So we start with that. We start with judges are neutral and detached and fair and impartial. And then we start with the respect for that rule of law and our obligation to uphold that rule of law. And so on the Court of Appeals, we do not have pride of authorship, although there is one person who is assigned to write the opinion. The opinion that comes out is truly a collaborative work between all of the judges on the panel. So the law clerks, we each have 2 law clerks who are students who have graduated from a law school who come to work for the judge, and they help us draft opinions. They will research case law. They will certainly and absolutely review the record and the transcript. We sit down with all our law clerks and say, here is the briefing in this case. Typically, because we are the intermediate court, we are about 85% criminal appeals. The vast majority of those cases are handled by the State Appellate Public Defender's Office, which was created in 1998, and the Attorney General's Office, who has an appellate division. So we sort of have the same 2 entities in our courtroom the most of the time. So we have briefs. The parties have identified the issues. Those are the issues that we address. We do not look at the briefs and say, well, there's a really great issue that somebody missed. We should just write about that. That is not what our job is as the intermediate court. So the issue has been identified for us. So our staff attorneys will help us draft an opinion. That opinion is then circulated to the 2 other judges on the panel. They edit as much or as little as they like. But as a member on the panel who is not authoring, we all take very seriously our obligation to also go read the briefs and review the transcript and record, because you can't make good editing suggestions if you don't have a basis of knowledge to work from. So we make both substantive suggestions and sort of mechanical suggestions. Should this be a semicolon or a comma? Do we really want this paragraph? Do we want to include? Do we want to exclude? We work very hard to have unanimous opinions on the Court of Appeals. And I do not, when I say that, I don't mean to say that we subvert if we truly disagreed with an analysis or an outcome. But if we are going to ascribe to the rule of law and parties need predictability about how the courts will decide their issues, it's not particularly helpful if you're getting a lot of 2-1 decisions. Because what that tells the party is the appellate court judges really don't agree on this issue. So how am I supposed to know how this issue should come out? We do have dissents. We are thoughtful about our dissents, but it is a very collaborative process. So I will go through, as an authoring judge, I will go through several iterations of a draft with my law clerks. It will go to my judicial assistant, who is a copy editor, and she will review it for copy edits. It then goes to the other judges, they edit. I am free to accept or reject their editing suggestions. Generally, sometimes if they have an issue with a particular paragraph and they say, you know, I can sign on if we can change this, then we may conference a case. We, the judges at the Court of Appeals right now, and perhaps always my experience has been always, are very collegial, and there's a lot of camaraderie, and we are very comfortable disagreeing with each other's legal perspectives, not in an acrimonious kind of way, but often disagreements can lead to the best opinion because you are really refining and reflecting the issue as you write it. Oh, I have to admit somebody. Here we go. So once we get a consensus on the majority opinion, there may or may not be a dissent. It comes back to the authoring judge, who then reviews all of the edits. It then is reviewed for copy editing by one and perhaps two of our judicial assistants, and then the case is issued. We do not, so the Supreme Court publishes all of its opinions. The Court of Appeals does not publish all of our opinions. And we don't, for reasons, although I will acknowledge there are disagreements about how much publication or how many of our opinions should be published. So unpublished opinions cannot be cited for precedential value. So in subsequent cases, if we have issued an unpublished decision, that decision cannot be cited to us as authority. Because the Court of Appeals hears anywhere between 600 and 650, 670 cases a year, there are some issues that have well-established case law, and we are not adding anything to that established body of case law. So we typically would not publish that opinion. If it is a new statute that is, not a new statute, a case in which a statute has not been addressed previously, or it is a new issue around well-settled case law, then we would publish that opinion. So the vast majority of our cases are unpublished. The Court of Appeals schedules 12 oral arguments a month. We do not usually hear that many appeals. Again, because the State Appellate Public Defender's Office and the Attorney General's Office appear most frequently in our courtroom, as entities, they are fairly well acquainted with the kinds of issues that would add to the body of law or would not add to the body of law. And as a former appellate attorney, I can tell you how much work goes into preparing for an oral argument, and it is significant. Their caseloads are such that they are not going to argue every case. They are not even going to ask for argument in every case. They do not have the time to manage the written caseload that they have and do all of those cases. And they also acknowledge that there are some cases in which oral argument might be difficult. And so we hear Generally, if both parties request argument, we will grant argument. If parties really don't want to have argument, there are very few instances where we have asked them nonetheless to come in and provide oral argument to our court. No additional questions as yet. So even in cases where the Court of Appeals disagrees and we have a dissent, we do not write like Justice Scalia wrote. We try to be very thoughtful and remember that we are discussing issues, not people, and that trial court judges are by and large really good judges who try to get it right every single time they make a decision. And it is one thing to make the wrong call, and it is quite another to have gratuitous comments about the way you made that decision. And so we try very hard to, even when we are reversing a trial court judge, to be thoughtful about the language that we use in that reversal. So we do not decide issues based on political pressure. We do not decide cases because we think they should come out a particular way. We look at the facts that are found by the trial court judge. We identify the relevant law that applies to that case. We apply the law to the facts, and the conclusion is what the conclusion is. And if you do it in that way, then there isn't an emotional attachment. There isn't an emotional link to the way the case should come out or what should be the outcome. Because what should be the outcome is the outcome that is dictated or the conclusion that is drawn by the application of the facts and the application of the law to the facts as found by the trial court. There are, and I'm surprised I haven't seen questions about this. Well, I should ask Dean Burnett if he wanted to ask any questions about publication of opinions or thoughts or comments that he would like me to address.
Now, I think Her Honor knows that I've accepted that office in the past. I think it's important to publish respect for the operation of the rule of law and published opinions. By the way, a non-published opinion is still a matter of public record.
It
If
is.
you know about a case, Smith versus Jones, you can go on the website at the Supreme Court and look at you'll find that decision. So it's not a secret decision. But publication means it's distributed widely. It's in Bar, that there are even limitations that can be done, and if there are 600 cases, we can every year write a public worthy opinion. So it's a striking balance between the practicalities of getting cases decided in a meaningful way and getting them decided with statements of reason that make clear to the public that these are not simply preferences that judges personally have and quickly use to dispose of cases. There is a little bit of an intermediate aspect of it that you might comment on. That's what we call the per curiam opinion.
I was just, thank you for that, Dean Burnett. So what's really interesting is that when I graduated from law school, unpublished opinions were truly unpublished. They weren't available in the reporters. They weren't available on Westlaw. They weren't available on the Supreme Court website. The parties would each get a copy. And there was some concern that, again, because the State Appellate Public Defender's Office and the Attorney General's Office were doing all of these criminal appeals, they had access to this body of information that private defense attorneys or prosecutors may not have access to, right? Even if a decision is unpublished, if it's an issue that you have and you can read this unpublished opinion and you get a sense of how the court might come out, might be a perception that you have an advantage in that context. But when I started, unpublished truly was unpublished. Well, now the unpublished opinions are on Westlaw, they're on the state court website, so they are unpublished and they are not to be cited for precedential value, but they are frequently cited to us in a footnote that says this case is not cited to you for precedential value, but it illustrates a way that this court has decided a similar issue in another case, which really is citing it to us for precedential value. But so there was a push to take what was truly unpublished and make that body of information more available by putting it on the website. It is published by Westlaw. So in 2007, there was a commission put together, chaired by Dean Burnett, which really looked at the workload of the Court of Appeals. And it recommended that we go from 3 judges to 5 judges. Well, now we're at 4 judges, so we got 1 out of 2. And thereafter, and I believe that Judge Lansing was the chief judge at the time. So almost 50% of the Court of Appeals workload, probably about 50%, maybe 60%, are what we call sentence reviews. And those are cases in which an individual has been convicted and he is asking the appellate court to review the term of his sentence. Because although you don't have a federal or state constitutional right to appeal, you do have a statutory right to appeal the final decision of any trial court. So that's about 50% of the case law. The standards are clear. The way in which we review those decisions is clear. The case law about what trial courts have to do to sentence appropriately is pretty well established. So Judge Lansing met with the State Appellate Public Defender's Office and the Deputy Attorney General and said, look, we got to get a handle on this. So those kinds of briefs where they're just sentence reviews have a different process. We used to have to make 9 copies of a brief. We don't do that anymore because everything's electronically filed. But those became staple briefs, and they would have a more limited factual background, a much more limited standard of review and analysis by the parties, because the standard was so clear in the appellate court. And so those are issued per curiam. They are not assigned an authoring judge. Those are just decided in panels of 3. And it was a way in which to take these kinds of cases, remembering that every case is a very important case to the party that is bringing it, but sort of fast track those cases in a way that perhaps more complex issues couldn't be fast tracked. And particularly in cases of sentencing, if there was a time that we were going to reverse a sentence, we would certainly want to do that sooner rather than later so that there is some meaningful relief for the party who's bringing the appeal. So there is some real value in looking at those cases a little more quickly. And by the same token, for the Department of Correction and the executive branch, if that sentence is final, we want to know that it may affect where that defendant is housed or the access to programming that that defendant might get. So those cases became per curiam cases, and those are fast tracked a little bit. By statute, there are other cases that are on expedited. Those are not expedited. There is no formal expedited process, but the court rules were changed to allow us to look at those cases perhaps more efficiently. There are some cases that by statute are fast tracked. They are called expedited appeals. Primarily, those are family law cases, because the issues in those cases need to be resolved as quickly as possible while still thoroughly reviewing those issues. There are federal requirements that are related to that, but really, if you are trying to adopt a child or you are having your parental rights truncated in some fashion, whether it's through a custody dispute or a termination, that needs to be decided quickly, because there are very important familial relationships at issue that can be damaged or impacted if they are not done quickly. Any other questions from the audience so far? Okay, so there are significant differences between the state and the federal system. And I'm not going to spend a lot of time. We have about 10 minutes left. I will tell you that the contentiousness and the aggressiveness that you see in perhaps federal court nominations, we do not see in the state court. And the reason for that is that federal courts, the district court, the Court of Appeals, of course, the United States Supreme Court, are lifetime appointments. Ours are, as we've talked about, for terms. There is also usually questions about judicial activism. And are you an originalist? Are you a living constitutionalist? How do you interpret statutes? How do you interpret the Constitution? I think those are fascinating academic questions. But I think realistically, when you are a trial court judge, you are not, or an appellate court judge, you are not affixing a label to the way in which you decide a case, because every case is different. And you may use a different method or more modality of constitutional interpretation depending on the issue in the case, or you may use a different method of statutory construction depending on the issue in the case. And I don't think even United States Supreme Court justices who self-identify as a particular school of thought are 100% married to using that method when they decide a case. And so I think a label can be a bit of a lazy way or an excuse for a judge to say, well, I'm going to decide the case in this way because I am an originalist or I am a textualist. And that's not what judges do. We have to take each case as it presents to us and decide that issue. And so I think we have to resist the urge to give ourselves a label and then only operate within the confines of that label when we are deciding a case. Because remember, the importance is that a judge is neutral and detached, and I don't have an opinion on the issue until it comes in front of me and I've figured out what the facts are and what the law are. And oftentimes, if I attach a label to the way in which I decide a case, people make a lot of assumptions about me as a judge, about perhaps my political affiliation, about the way in which I will decide a case, how I will decide future cases. And I don't think that would promote the rule of law. It would not promote public confidence in the judiciary and the way in which we decide cases if they thought they could go down the row and say, this judge is this, and this judge is this, and this judge is this. And so, although there is lots of talk about that at the federal level, and you will see it in these contentious confirmation hearings, we typically don't see that in Idaho appointment through the merit selection process. And it's been a long time since we've had a contested election on the Supreme Court. Back in 2016, I think, when Justice Brody was elected ultimately. And so I have not had sort of an experience where I've had to stand up in a public debate and say, I am X and I do Y. Yeah.
So have you perceived, though, the public confidence in the judiciary in Idaho vary or fluctuate over time as they perceive your decisions or the Supreme Court's decisions, or throughout your time both as a district court appeals? Or has it been pretty consistent, do you think, that the public's confidence in the objectiveness of the judiciary?
I would like to think that the general public reads our opinions as something fun and interesting. I think the reality is that they probably do not. So I don't know. I think sort of we have nationally seen less public confidence as people see more media stories about the politicization of judicial selection and judicial processes. I think they probably infer or believe that politics similarly affect the judicial process in Idaho. In all of my years, I have never known a judge to make a decision based on political reasons. I mean, ever. I have talked to judges who have said, I had this case and I knew that this case would mean I would not get elected again when I issued my opinion. And I did what I thought was right. And if it meant I lost my job in an election, then I was willing to take that risk. And so I don't think the public is particularly confident right now in elected officials generally, whether they are judges or any other kind of elected official. And so I think that we have, as judges and as attorneys, really an affirmative obligation to do public outreach and talk to the public about how judges make decisions and the lack of politics or polarization that exists, at least in the Idaho judiciary. I can't talk about the federal judiciary because I don't have that experience.
So the Idaho legislature tends to pass bills, obviously. So when you are applying them in that mechanical way, the result might feel political. Do you ever say don't like, I'm just applying the law as it is your representative?
So I don't think I've seen a Court of Appeals opinion where we have.
Excuse me, Judge, could you repeat the question? I don't.
Yes.
think that the audio.
So the question was that the legislative bills in Idaho tend to be politically based. And if the Court of Appeals is called upon to rule, to make a decision about that statute or interpret that statute, the outcome may feel political because the initial substance was political. And so do we ever write in our opinions, this is not political. If you don't like the law, that's the job of the legislature, and go talk to your legislators. I don't think the Court of Appeals has ever issued an opinion that said that. There was a case called Verska, which is about statutory interpretation. And in that particular case, the Idaho Supreme Court sort of reversed its precedent on statutory interpretation and said, in Idaho, we start with the plain language of the statute. And if the plain language leads to an absurd result, so be it. The creation of a statute is the purview of the legislature, and it is their job to write the law. It is not our job to interpret them in a way that changes the meaning of the legislation. And so we now begin all statutory interpretation cases with the plain language of the statute. I do think our Supreme Court has to make decisions about political issues, and at least in the opinion that I am thinking about, they did not put in the opinion that if people were unhappy with the outcome, they could contact sort of the legislators. Because again, they try to be thoughtful about the language that they use and remove the political aspect from the opinion. The opinion, the issue is about the law, is about the language of the statute, not the political parties that passed it. And so I think Verska was the closest that I've seen where they've specifically said that is a legislative function and there is separation of powers, and we are not going to weigh in on that. Any other questions? None yet. Okay. So in addition to ways of interpreting the Constitution, there are ways of interpreting a statute, and there are different ways. But if those ways become by precedent a sort of required modality, a required method like textualism, you start with the plain language of the statute, that operates as a judicial restraint, because the Court of Appeals now is not permitted to interpret that statute in a way that does not start with the plain language of the statute. I honestly can't think of an instance when we would, because you have to start somewhere. And so starting with the language seems to be the easiest and most practical place to start. But there are other places where dictating the method by which the substance is decided becomes as much a way of interpreting as a method of mechanically reviewing things. So it has been an hour. I have, I believe, 3 minutes left. I am happy to stand for questions if we have any, either from the Zoom chat or from here. And if not, I really appreciate the opportunity to talk to you. If you have questions, please come up and talk to me afterwards, or I am here at the law school for the remainder of the week until Friday at about noon, and I'm happy to have visitors. So thank you. Oh,
just a comment, if I may.
please.
This is your presentation.
No.
But two occasions to record it. not as though the court is just another rung on a ladder that has to be traversed. What is the, if you have it close to mind, the rate at which Court of Appeals decisions are taken up for review and then either upheld or overturned at the Idaho Supreme Court level?
So in case anyone didn't hear the question on Zoom, the question is, Idaho's Court of Appeals as an intermediate court is really a court of final review for many cases unless a petition for review is granted. And the question was, how many cases are taken on petitions for review, and at what rate is the Court of Appeals either affirmed or overturned as the Supreme Court looks at that? I don't have the numbers to hand. It does seem in the last year there have been a fair number of petitions for review granted, and I would say that the Court of Appeals is reversed more than it is affirmed at sort of in the last 12 months, but I have not done a statistical analysis of, are the identical issues being reviewed, and is it just different legal reasoning, or is it ultimately just a different legal conclusion?
May I add something to your statement that politics doesn't have the same impact in the state judiciary as it is perceived to have at the federal judiciary. And in the Idaho Code of Judicial Conduct, a judge or a candidate to become a judge, either by appointment or election, is prohibited from making a pledge or a promise of an outcome on an issue that's pending or may become impending in the court. We see in the United States Senate, senators engaged in a kabuki exercise of talking to their bases by way of trying to extract from potential appointees pledges or promises of how they will rule. That probably is a violation of the federal statutes relating to the judiciary, and it would be a violation of the Idaho Code of Judicial Conduct. So there is reality here to this non-political aspect of an independent and impartial judiciary.
And there have been circumstances when a non-judge is running in a contested election, and in theory, the Code of Judicial Ethics applies to that candidate, even though he or she is not yet a judge. Because otherwise, this candidate could say whatever he or she wished, and the sitting judge as a candidate is very constrained about how he or she could respond to questions or answers or ideas, and it creates a real imbalance. And so, knock on wood, there have been no Court of Appeals contested elections yet, but we just do not have that kind of acrimony yet. I say yet, I hope never. The State Bar is very collegial. Judges, it's a small bar. Everybody knows you and knows about you. So I would agree that the judges that I know, and that's a lot of them in this state, take their judicial ethical rules very seriously and work very hard to stay within those ethical parameters. So thank you, Dean Burnett, for pointing that out.
And thank you, Judge Huskey, for that provocative and insightful look behind the curtain of what happens in Idaho's court system. And it's been great to have you on campus, and wonderful to have audience both on Zoom and in the classroom. So if you on Zoom, if you'd like to put up your hand, and those here in person.
Thank you.
And I hope you'll join us next week for something entirely different, a tour of the Bar Insect Museum in the College of Agricultural and Life Sciences. And we'll have details on that in the weekly announcement that will go out Thursday or Friday of this week. So thank you, everyone, for being here today, and enjoy this wonderful spring day on the University of Idaho campus.